sexual assault is one of our specialties. And
pretty much.
And then there's variations of sexual assault with a weapon. Sexual assault causing bodily harm, aggravated sexual assault. It can be called a number of different things. And it's really interesting when you look at, I think everybody's, well, unfortunately not very clear on what a sexual assault is, because it ranges so far from like patting somebody on the bum to actually having
That's a great point. So this podcast, this episode, initiated from an inquiry about why is sexual assault such a broad definition, which is a really great question, because in the United States, they have insane definitions of all sorts of things. But to their credit, there's categories. So we want to talk a little bit about the breadth of sexual assault and the various charges.
And I've said before, and needed to clarify, so we need to bring back rape. And it's like, not bring back rape as something that people do, but bring it back as a category to separate it out from things that are like simple sexual touching.
Right, which is very interesting. So just, we're going to go into the definitions and sort of define all this.
This is a bad soundbite. We need to bring back rape.
But in cases where we have complainants testify and they go, I was raped. That word is very popular.
That word, yeah.
And they use that because it fits the definition of what we would think is a rape, right? Pushing somebody down on a bed, forcibly penetrating them, that's a rape.
Yeah.
And that has sort of a emotional, objective understanding of what a rape would be.
Psychological damage factor.
And physical.
Yeah.
So, but in Canada, sexual assault can encompass a broad range. It can be from a touching of an area of the body for a sexual purpose. So,
and for those people who say, oh, well, you can't categorize the trauma from a degree of this or that, it's like, no, seriously, you can separate out the trauma caused by somebody inappropriately grabbing your buttocks to somebody pinning you down and forcibly having penetrative sex with you.
That's right. So sexual assault...
There's a definite difference in the amount of trauma.
Let's be clear. Sexual assault is a non-consensual touching for a sexual purpose. That's like, I'm just dumbing it down. So that can be touching a thigh, the buttocks, the breast, and even a little bit more, sort of neutral in an area, but for a sexual purpose. And that's really important because it's extremely broad. And sexual assault can go from there to forced
and just to be clear, you're flipping through the criminal code.
Yeah, this is a criminal code. This happens to be Tremere's Criminal Code, 2024, which is, Justice Watt and Justice First, who are excellent judges. And we have Martins as well, and we love that too. But this is what I'm referring to at the moment.
Because
but so
the wording
touching,
is so. We're going to get into this a little bit further.
Important.
Wording is very important in the criminal code, and it's very important that people in Canada, which this criminal code relates to, and people in other countries, the same thing would apply to them. It's important to know if you're breaking the law and how it's worded. Ignorance of the law is not a defense, right? But you need to know whether or not what you're doing is breaking the law, even if you don't realize it.
That's right. So first of all, because this is sort of like a really basic back to principles type of podcast here, it's really important to speak about the breadth of sexual assault and then go into the other areas. So it can be from a touching of a leg, a thigh, a buttocks, a breast, an unwanted kissing, an unwanted touching, to, unwanted...
Strangely, touching of a penis that's unwanted, not usually included.
I've never had one of those cases.
I know. I haven't seen one either.
To then when you get into more egregious activity, like a forced sexual act, like a forced fellatio and other things. So it's very broad. And that includes a forced intercourse with all sorts of other activities. Very, very, very broad.
But when you say forced, people think of actual physical force. And, what we're going to get into is
psychological force.
So psychological force is the thing that causes a bit more problems in terms of people saying, huh, what? Because somebody can even say okay, but that okay can be vitiated by some sort of ominous feeling psychologically.
Yeah, so we're getting into nuances. I'm using that in the basis of...
I'm jumping
something,
ahead.
I'm using that in the basis of something that's unwanted, non-consensual. So in other words, it's it's foisted upon someone else to comply with, or it's being done to them without their consent and with their resistance, okay? Even though they don't have to resist.
Well, we're saying with their resistance, but
Right.
yeah, that's the problem.
So that's a very broad definition. So we don't use the term in Canada rape like in the United States. We don't have first, second, or other degrees like they do in the United States. And then you can have...
We do have aggravated or whatever.
Well, then we can have sexual assault, which is very interesting.
It's just very interesting.
You know, you can have sexual assault, bodily harm, or with a weapon. Can you explain that one?
Right. Okay, so a weapon, and this is something really interesting. A weapon could be a variety of things. And some of the cases that have stood out for us, some of them being cases that we've defended, but one is I came across was assault, not sexual assault, but assault with hot noodles. The hot noodles were the weapon. So the person threw hot noodles at somebody, and it ended up, they were quite hot, and it ended up with like third-degree burns or something like that. But so hot noodles can be a weapon. We had a case in which the weapon was a dildo. And interestingly, it was a dildo that the person bought to be used upon themselves. And then there's like another case where we were looking it up, and the judge goes, one of our favorite judges, I didn't realize a dog could be a weapon. So just having a dog who looks vicious,
that's true.
you know, can actually be seen as a weapon. And so here's the interesting part. Using the threat of a weapon, even if you don't actually use the weapon, is the equivalent to assault or sexual assault, whichever one it is, with a weapon.
Right. So let me read the section. So section 272, sub 1 of the Criminal Code. Sexual assault with a weapon, threats to a third party, or causing bodily harm. Every person commits an offense who, in committing a sexual assault, carries, uses, or threatens to use a weapon or an imitation of a weapon.
Or threatens to use.
Threatens to cause bodily harm to a person other than the complainant. Causes bodily harm to the complainant, chokes, suffocates, or strangles the complainant, or is a party to the offense with any other person. That's a lot there.
There's a whole bunch in there. Yeah.
There's a lot in there. Commonly, we think about bodily harm, sexual assault with bodily harm, where there's an injury to the complainant that is more than trifling in nature. So it's not a transient sort of injury where, you know, you're feeling a little bit of pain. It's something much more substantial than that, where there's a bodily harm. But it also involves cases of a weapon or the threat to use a weapon. That's important because it can be just a threat to use it, which induces the sexual assault. It can involve choking or strangling. And again, we've spoken about
that aggravates the charge too, escalates the maximum number of years.
It does. And that we've also used this in conjunction with talking about the BDSM play area, where people think it's okay to consent to choking or suffocation.
When there's
and
an
guess
extra
what?
charge,
It's not.
Choking to overcome resistance.
Well, that's even more. That's another offense. But sexual assault with a weapon, threats to, or causing bodily harm can include chokes, suffocates, or strangles. So this is where we spoke about in the BDSM community, where they're consenting to this type
really
of behavior.
Common. Yeah.
So that's included. Or where you're a party to the offense. So let's say you're in a gang situation where you're watching or encouraging the sexual assault of a person. You can be included in something which is just more than a sexual assault by being in some way aiding and abetting, or a party to it by counseling, watching, other circumstances. And that has to be more than just simply being a bystander. But this is important to understand.
When you're saying you're in a gang situation, it sounds like a gang rape situation, but it could be a situation in which somebody is having sex with other people around them. So you're not necessarily part of a gang, but you're just part of a community in which somebody is having sex, and you're
That's a nice way of putting it. Yeah. Look, okay. So let's say, of course there are activities where there may be observers, and people may enjoy that. But if there is...
Or ignore it, but you could be present in the room.
You got to be careful about that. People can be included in it. And then there's aggravated sexual assault. Every person commits an aggravated sexual assault who, in committing a sexual assault, wounds, maims, disfigures, or endangers the life of the complainant. So, that is very
maims, disfigures,
significant.
Obviously.
And there's aggravated assault also can include if there is a weapon used, like a firearm, for example, in the commission of the offense.
It doesn't even have to be a real one, right?
Correct.
It can be a fake one or whatever. It's like,
so this can include, injuries that are serious. So where we say...
Can that include putting your hand in your pocket, pretending you have a gun?
It's kind of hard. But possibly.
I've seen too many movies.
Yeah. But wounds, maims, disfigures, or endangers the life of the complainant. This is a fairly significant threshold. So there has to be a significant injury that is more than simply trifling in nature. So it's significant injury. So let's say there's serious lacerations that are caused where there needs to be stitches.
And don't undermine what can happen with a dildo. Just tying it back to the beginning.
True, but it's important to understand the degrees that are involved in sexual assault cases. So it goes from a sexual assault where there are no real injuries, but it can be a full-on sexual assault that's punishable up to 14 years. Then you can go to bodily harm, where
when you're in Canada. If you're in the States, you're going away for life, I think.
Yeah, and people don't quite appreciate the difference.
Other sentences in the US are insane compared to Canada.
For example, for assault with sexual assault with a weapon or bodily harm is punishable up to 14 years. And then aggravated sexual assault is up to life. So this is very important for everybody to understand that there are these degrees. What's most common that we will deal with in Canada is sexual assault, which again is this broad
just
area.
Just the basic sexual assault,
Yeah, like your basic burger.
Your basic.
Yeah, your basic burger. So, but that's punishable up to, again, 14 years or less. But the
basic is 10 years, but with a weapon is 14 years.
That's a good point.
Because we've been talking about with a weapon, but the basic one without any aggravating factors is punishable up to 10 years in Canada. Yeah.
But
which is significant.
Yeah, but what's really important is just the broadness
of what's called sexual assault.
Right. So that is very significant for people to understand. It goes from a touching all the way up to intercourse and other particular acts without consent, which I will just say for this episode is forced sexual acts. And then up to where there can be a significant injury, up to life imprisonment. So the question that the person posed to us was, why are we categorized this way? I think our system actually, for the most part, makes sense, because the way they have it in the United States, I frankly don't understand. First degree, second degree, all sorts of stuff. I think this is much easier to understand. However, I would like to see the sexual assault provision changed.
Yeah.
When you have touching versus something that's much more invasive, I'd like to see that parsed out.
Yeah, like that's what we were saying, like, the charge of rape, there's a number of reasons why they just changed it to sexual assault. It just encompasses too much. And so you can be charged with sexual assault for slapping somebody's butt. And,
that's correct.
And if the public finds out that you're charged with sexual assault, they just assume the worst, right? So,
well, what's the consequences? Let's say somebody is convicted of sexual assault, which includes grabbing a buttocks and touching a breast, okay, and saying some words. Mm-hmm. They're convicted. What's the consequences of that?
Well, you get put on a sex offender registry.
Right. What else?
And there's actually not a minimum anymore, but depending on age, but you're still treated like a sex offender, the equivalent of somebody who's done a
You're on a sex offender registry, your DNA is taken, and you can go to jail.
It usually has jail
sentence. You for sure will get a conviction.
Almost always has jail sentence.
You for sure will have a conviction, and then good luck with respect to getting jobs where there needs to be any type of real background check.
Yeah. And crossing the border sometimes.
Forever in the United States.
Yeah.
So it's very significant.
No matter how different the touching assault may be from an actual full-on penetrative rape. Sexual assault, we say in Canada, no matter how different that is, the consequences are still very similar. It's just a difference of how much jail time you spend.
Yeah, but what's significant is...
Do not go gentle into that good night. People quite often just think, oh, well, you know what, she's accused me of this, touching her butt or something like that. It was like, they don't take it seriously enough. It is serious. It's a good point that you're making.
Yeah, I think this may be boring to some people who's watching this episode, but it was an interesting question that was posed to us. And it's not something uncommon that we deal with when people come in. That a sexual assault allegation, although somebody may think it's rather simple or not that significant, even if it just involves an unwanted touching, is very serious. Because the consequences of a finding of guilt is very significant. And again, people have to remember it can be prosecuted by way of summary conviction or by way of an indictable offense to imprisonment of not more than 10 years. But if the complainant is under the age of 16 years, to imprisonment of a term of not more than 14 years, and to a minimum punishment for a term of 1 year.
If the complainant's under 16.
16.
It's, it's always a serious charge, and the, the degree of the allegation or whatever is kind of irrelevant when you're looking at the future.
Let me just finish. And if punishable on summary conviction, liable to imprisonment for a term of not more than 18 months, or if the complainant is under the age of 16, to imprisonment for a term of not more than 2 years less a day, to a minimum punishment of a term of 6 months. So there's minimum punishments. It's significant given the age of the complainant. And the finding of a guilt with respect to a sexual assault, simpliciter, let's call it that, is really life-altering.
It is. Well,
and it's this broad range.
Having to go through the whole process of the criminal trial process is life-changing, life-altering. But once you're charged, there's very little that can be done to have it withdrawn, because there's a mandate to go forward with these for a good reason, but to some degree. But unfortunately, it doesn't get reviewed properly. But we have a really interesting case coming up, in which, and this is a point that we've made before, that quite often you'll find yourself charged with one thing and then a bunch of add-ons, right? So we have somebody charged with a sexual assault and then uttering threats to cause bodily harm or death. And that charge was added because the person said, the person told me to have a drink or else. Or else what? I don't know, it didn't say. But this ends up in a charge of uttering threats to cause bodily harm.
Right. In conjunction with the sexual assault.
In conjunction.
Which heightens the sentencing on this. And again, this person couldn't actually articulate what else is.
Or else what? It was actually asked by the police. Or else what? Was there a consequence named? And it was like, not really. But I just took it to be a threat. So therefore, there's another charge added on. This is the same thing, too, when people, we've mentioned, if they want to try and video something to prove they had consent, well, you can get charged with voyeurism on top of it.
We have that.
Right.
Yeah, we have that in another case. I think, what's important to consider for this is we have in Canada, I think, a pretty good idea about how to categorize sexual assault related offenses. The difficulty I have, and I think what our viewer wanted to discuss, and I think it's good educationally, is that so much is encapsulated just in the basic concept of sexual assault. You have to then keep a mind on what the age of the complainant is with respect to sentencing, and that we have such a gradation of touching to more invasive contact all the way up to forced intercourse, anal intercourse, forced fellatio, etc. That's a pretty big spectrum.
It's a lot of factors, yeah.
It's a big spectrum for which you still are convicted of sexual assault on the sex offender registry, labeled a sex offender, with all the consequences from there. And I think this should be broken down where you have something less than, when you're in the touching category, I think we need to have some sort of an amendment there. Nobody will listen to me on this, but I think that's important because of the consequences. But it may be just, it may just be words. It may not really make much of a difference. But I see this as a significant issue for the future for individuals if they're found guilty of these offenses.
Yeah, that was a pretty good list. And there's one extra one that I thought of that was kind of left out, is that if you're in a consensual relationship, but you're in a position that's deemed to be a position of authority or trust, then that can actually undermine and vitiate the consent as well. So people need to be aware of that.
Yeah, we spoke about that before, where we talk about, how they use sexual exploitation And if you're found to be in a position where you have some control or influence over somebody, then you can't, maybe you can't have a sexual relationship.
Spiritual advisor.
Yeah.
A medical professional of some
sort.
Well,
but there are categories where legitimately somebody is in a position of authority, and that would be a situation where you should not be having sex with somebody.
Right, because even if they consent to it, they can then go back later and say, "Oh, well, I trusted them because they were in this position in my life." Right. So that's always.
But we have an active case now where, again, it's a situation where truly they were not in a position of an unequal power dynamic, and that can be exploited by the prosecution in various cases. We don't see that really that much to be sort of exploited by the prosecution, but it happens in the case we have right now. Really, we see that the Crown has gone way too far on this allegation of exploitation. But it's a really broad category, and people have to be understanding of what's involved in each of these charges and how you have to go about defending it. And I hope that answers the question of this person who asked us what was an important question in my mind, because again, the categorization is really important, and then understanding the case and how you go about defending it. I just want to talk for 1 second about bodily harm and aggravated assault, because the corollary issue to this is, okay, in a sexual assault, you can defend it by saying, and again, the Crown bears the onus of proving lack of consent. But when I talk about defense, you can say, well, there was consent and our activities were all consensual, et cetera, et cetera. What about where there's an injury? What about where there's, an aggravated assault, and you have a wounding and a maiming? What are you able to do by way of a defense? So let's say you engage in a certain sexual activity where, as a result of it, there is an injury that results in bodily harm or an aggravated sexual assault.
This is especially important when we're trying to address people in the BDSM community to understand, the activities they're engaging in and what the risks are in terms of what people are permitted to consent to.
Right. So technically, on the law, nobody can consent to bodily harm. We've said this a number of times. So, a sexual assault causing bodily harm, a person can consent to a sexual act, but if it causes bodily harm, the person who is the victim of that cannot consent to that bodily harm. Whereas in certain communities or play, they may think you can, you can't. Right. Similarly, on an aggravated assault, the injury is more significant than a bodily harm. And again, that cannot be a matter of consent. So is there any defense to that? I might answer that question.
I think it's probably better if you do.
Okay. So there may be a defense of accident as to consequences. So if you engage in an act, not thinking or knowing, you can't be willfully blind. But if you engage in an act and an injury results from that, you may be able to argue, depending upon the constellation of facts at the time, that there was no intended consequence of an injury. In other words, it's a simple accident. Mm-hmm. I would not have been able to know in the circumstances that an injury would result. It's a complete accident of what we were doing. So although you had the intent to have sex, you did not intend the consequences. So there was an accident as to consequences.
And I would argue on top of that sometimes the complainant themselves did not foresee the injury.
Right, because the point that you're raising is somebody may have consented. Let's be blunt about this. Two people may have said, we would like to engage in this type of sexual act. It's inherently dangerous. It's Barton, right?
Well, Barton is a great example because that was 2019, and it's, it's been heard and decided by Supreme Court.
That a particular act.
And a particular act was seen as inherently dangerous. And so they engaged in that act, and the person unfortunately passed away because,
they bled to
one
death.
person fell asleep while the other person was bleeding in the bathtub, totally unaware that there was some sort of trauma or medical emergency taking place.
Yeah, so that was incredibly, tragic. So just think about it. Two people may consent to an act that could be determined to be inherently dangerous. The injury that results from that can result in a very serious conviction, manslaughter.
Which ultimately ended up happening.
Right.
Yeah.
This is really important to understand because some people do engage in, and we happen to have a couple of these cases, where the parties clearly was contemplating, consenting, and wanting desperately to engage in this, sort of alternative, highly aggressive play. And injuries occurred. Thank God nobody died. But serious injury. And the only legal defense to that is the person who was the receiver did not necessarily contemplate the injury, and the person who was the giver,
and was expressing enjoyment of the act at the time,
and afterwards saying, I loved it.
Yeah.
And the giver, who's the accused, was not necessarily attuned to the fact that an injury would be caused. Right. So it's a very thin line of a defense where it's really an accident as to consequence. That's it.
Yeah.
So when you think about sexual assault and the broad category, then you get to particular acts of sexual assault where there could be foreseeable injury. You have to be really careful about that because there is virtually no defense to that. Yeah. You can't consent to bodily harm. You certainly can't consent to an aggravated injury or an aggravated assault. It's a very limited and very thin defense that would be available. And it has to be in circumstances where you would not be reasonably able to understand or know that an injury would result as a result of your behavior. If you're doing something, I'm trying not to be graphic, but you could be engaged in something where you really should know it's going to cause injury, right? Because of
there's a good chance.
Because of the size of the person and the particular act and the aggressiveness of the act, it's going to cause injury. If you're attuned to that, or reasonably should be, you're going to be guilty of that.
Most likely, yeah. But it's surprising what people actually do consent to.
No, I know, but this so I found it so
This is a problem though, because judges, especially if you have cases where there's video for whatever reason, right?
Ours has a video.
People watch that,
like a full video,
and they'll, even if the person was consenting, they'll be like, they have trouble understanding why somebody would consent to that. So it's another thing for the BDSM community to really think about and understand.
And it's not even necessarily the BDSM community. Right now we're faced with a couple of these cases where these are not, they're kind of BDSM players, but they're not really. And they're kind of just experimenting, not really knowing.
They're not going to dungeons with crosses and all this.
No, and they're not in the activity. They don't have these contracts and everything. And so that's why I found it very intriguing when we got the question about, can you talk to us a little bit about the broad definition of sexual assault? And I thought, it's so interesting because people may not understand the breadth of it.
Given what we've talked about, what can be a weapon?
And even just the threat of a weapon.
I know, you don't even have to use a weapon.
So it's really complex and you've got to be very careful about it. And I guess the upshot of this is there's a lot of stuff that for those who are interested in certain areas of play, you got to be really careful.
Yeah. And, and go about as much as possible confirming that you have consent. But again, most of the time, it's in a box. And so it's just going to be your testimony about consent. Really just know your partner, I think, is the most important thing.
Well, don't engage this with a stranger, that's for sure.
Yeah.
But, again, you can't consent ahead of time to something that would cause injury.
Right.
And that's something that has to be, so contracts...
Well, you can't consent ahead of time to anything.
Contracts aren't going to work. Well, that's right. But just be aware of the breadth of what's involved. And then when there is injury involved, it's a very thin line of a defense that's available. Possible, but very thin line. And I don't have more to say to that.
I think this was a really good, nuanced kind of discussion about what people should understand. And I would say that people need to listen to this podcast or else.
Or else what? If you like this short, informative podcast about sexual assault and definitions thereof, Like, share, and subscribe. Good night. Thanks,
Leave
everybody.
comments. Thank you.